Welcome to the Deep Dive, the show where we really try to cut through the noise and get to, a genuinely informed understanding. Today, we're diving headfirst into something fascinatingly complex: property ownership. Specifically, how it works in these really difficult real world situations in Somalia. This isn't just dry legal stuff, it's about how laws collide with history, with conflict, even with basic human rights sometimes. And our guide for this journey is a really insightful legal analysis by Abdulsi Yabaro. He's a master of law, a legal researcher. His paper, it's titled Legal Limits of Long-Term Possession Over Public Land in Somalia, a jurisprudential analysis of Articles 757 and 775 of the Somali Civil Code. It digs into some seriously tricky questions about land rights, stuff you might not normally consider. So our mission today, let's unpack how these laws about long-term possession, what maybe you'd think of as squatters' rights, how they apply, or maybe more importantly, how they don't apply, especially in situations like state-owned property or displacement because of conflict, or even property that belongs to kids, to minors. We'll be using Yabaro's expert insights. Okay, let's get into it.
Yeah, and it's fascinating because Yabro zeroes in on these two articles, 757 and 775, from the Somali Civil Code. These deal with concepts like adverse possession or prescription, basically. The idea that you might gain ownership of property just by using it for a long time without interruption. And it's worth noting, Somali civil law actually gets a lot of its structure from Roman and Italian legal traditions.
Yeah.
So Article 757, generally speaking, it describes how someone could acquire ownership. It used to be continuous possession, peaceful, public, unequivocal, and crucially with what's called animus domini.
Animus domini, what's that exactly?
It's the intention to actually own the property, not just, borrowing it or using it temporarily, but possessing it as if you're the owner.
Got it. And Article 775.
That one sets the time frame, usually 10 or maybe 20 years of that kind of possession. But here's the thing Yabaro really highlights. These rules were meant to bring certainty, but they have some really critical limits. His analysis shows where they just stop.
Right, and that's where it gets super interesting because, like you said, Yabaro makes it crystal clear these provisions have boundaries.
Yeah.
They definitely don't apply everywhere you might initially think.
Exactly. He points out three main areas where these long-term possession rules they don't work, no matter how long someone's been there. First, state-owned property, public land. Second, property that was taken when people were displaced, during conflict. And third, property that belongs to someone who can't legally contest the possession, like a minor, a child.
Okay, let's make this real. Yabaro gives some powerful case examples that really illustrate these points. As we talk through them, maybe you listening can think about what your gut reaction would be. So, first case. Picture a family. They've lived in a house since, say, the 1980s or early 90s. It was originally a government house given to a public employee who then retired. The family just stayed. For over 30 years, now they say, it's ours. You might think, well, 30 years. That's a long time, right?
Well, according to Yabaro's analysis, their claim, it fails completely.
What?
Because it's public property. The government owns it. There was never a legal transfer, no title deed changing hands. And under Somali law, as interpreted here, public land simply isn't subject to this kind of acquisition through possession through prescription. They're being there for decades. It was mostly tolerated because the state institutions had collapsed. It wasn't a legal right they had. So Articles 757 and 775, they just don't apply in this situation. It's a fundamental idea. Public assets aren't just up for grabs.
Wow. Okay, that's clear. Let's take the second case. This one feels, well, incredibly difficult. Common in conflict zones, sadly. A family in, say, Mogadishu, Baidoa, or Kismayo had to flee their home back in 1991. Civil war, clan violence. They just ran. Another household moves in. Maybe they say it was abandoned. And they've lived there ever since. Decades later, do the new occupants have a claim?
Yabaro's take is firm on this too. No, the original owners didn't voluntarily abandon their home. They were forced out by violence or fear. So the possession by the new occupants didn't start peacefully or lawfully. It started because of chaos and conflict. And crucially, displacement by force or fear. It actually suspends the prescriptive period. It's like the legal clock stops ticking for the original owner while they're displaced.
It pauses the clock.
Essentially, yes. Plus, there are deeper legal and, frankly, moral principles that say you can't gain ownership through conflict and dispossession. So again, Article 757 and 775, they're just not applicable here. It really throws into sharp relief the challenge societies face sorting out property after conflict.
Absolutely. And the third case example, this involves a minor.
Yes. Imagine a child, maybe 5 years old, inherits a house in 1992 because their parents tragically died. A relative moves in, maybe takes care of the place, maybe just takes it over and claims it. Years pass. That child is now an adult and wants their inherited property back. does the relative's long occupation win out.
What does Yabaro say?
He advises that prescription, that time clock for ownership, it simply doesn't run against minors. Someone who is underage lacks the legal capacity to defend their property rights in court. So the relative, the possessor in this case, they never had the legal standing to acquire ownership from the child. The law protects the child's rights until they reach adulthood. Ownership stays with the rightful heir, period. It's about protecting the vulnerable.
That makes perfect sense. So, stepping back a bit, what does all this mean when we look at the nuts and bolts, the actual legal requirements for prescription in Somalia, especially for public land? Why are these exclusions so firm?
Right. Yabaro really breaks down why the standard rules don't work for state land. He gives 5 key reasons. First, and this is fundamental, state land is inalienable without a legal transfer. You can't just acquire it privately unless there's a specific law allowing it, which Yabaro says Somali law lacks for this kind of situation.
So you can't just homestead public land by staying there long enough.
Not in this legal context, no. There has to be an official act, a proper legal process to take it out of public ownership, which leads to the second reason. The possession wasn't lawful or under a claim of right in the first place. For prescription to even be considered, the possession needs to start from some kind of legal basis, or at least good faith. If someone just